Okay, ladies and gentlemen, the international seminar will begin soon. Please, okay. Opening ceremony, international seminar on refugee law, convicting Acehnese fishermen who rescues the Rohingya refugee, a setback for refugee protection in Indonesia. Organized by the Faculty of Sharia and Law, Syarif Hidayatullah, State Islamic University Jakarta, Friday, 22 April 2020. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin wa bihi nasta'in ala umuri dunya waddin. Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajma'in. Honorable Rector of Syarif Hidayatullah Jakarta, Honorable Rector of Syarif Hidayatullah State Islamic University Jakarta, Professor Dr. Aman Lubis MA, Honorable Dean Faculty of Sharia and Law, Dr. Ahmad Talabi Kharli, SH, MHMA, Honorable Invited Speaker of International Seminar on Refugee Law, Heru Susetyo, Advocate or Associate Professor of Law and Society, Faculty of Law, Indonesian University, Professor Ance Misbah, Professor of Global Migration and Refugee Studies, University of Bielefeld, Germany, Dr. M. Adli Abdullah, MCL, Senior Lecturer on Adat Law, Islamic Law, Aceh Studies at Syah Kuala University, Aceh, Indonesia, Martin Jones, Senior Lecturer on International Refugee Law of York Law School, University of York, United Kingdom, Fitria, SH, MR, PhD, Chairperson of Center of Islamic and International Law, Faculty of Sharia and Law, UIN Jakarta. Honorable Vice Dean of Academic Affairs, Dr. Sahrul Adam, MAG, Vice Dean of Administration Affairs, Dr. Muhammad Maksum, MIMDC, and Vice Dean for Student Affairs and Cooperation, Dr. Haja Maskuf, MA, distinguished guests and participants of this international seminar. First of all, praise be to Allah Subhanahu wa Ta'ala, who has given tawfiq and hidayah to all of us, as well as the blessing of God, as well as the blessing of good health, so that in this holy month of Ramadan, we can carry out worship with all sincerity, asking for the pleasure of Allah Subhanahu wa Ta'ala. Secondly, salawat and salam to our beloved Prophet Muhammad Sallallahu Alaihi Wasallam. We give goodness and in the word the light of faith and knowledge, and save the human life from destruction in the safety. This is the right path of Allah Subhanahu wa Ta'ala. Ladies and gentlemen, welcome to International Seminar on Refugee Law. The theme, Convicting Acehnese Fishermen who rescues the Rohingya refugee, a setback for refugee protection in Indonesia. Friday, 22 April 2020. Ladies and gentlemen, let's begin our seminar by saying Basmalah. Bismillahirrahmanirrahim. Next, the opening remark will be delivered by the Dean of Faculty Sharia and Law, UIN Jakarta, Dr. Ahmad Talabi Kharli, SAG, SIM, HMA. The time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahi wa kafa, wassalatu wassalamu ala sayyidina al-mustafa wa ala alihi ahli sidqi wal wafa, amma ba'd. In the name of Allah, the compassionate, all praise is due to Allah, the Lord of the world and the creator of everything in the universe. We also have been giving us blessings and mercies, so we can attend this webinar this evening. Peace and greeting be upon the Prophet Muhammad Sallallahu Alaihi Wasallam, who taught us how to uphold justice and love the oppressed people. Honorable Professor Dr. Amani Lubis, Rector of Universitas Islam Negeri Syarif Hidayatullah Jakarta, distinguished speakers, dear colleagues and students, ladies and gentlemen, it's a pleasure to welcome all of you and deliver opening remarks for this evening's international seminar, Convicting Acehnese Fishermen who rescue the Rohingya refugees, a setback for refugee protection in Indonesia. We are happy as this seminar brings together prominent speakers from the three continents, Europe, America, and Asia. We hope that the evening Indonesia time is convenient for all. The Center for Islam and International Law, or CIIL, was founded in January 2022. This is our effort to have more impact on the community of science and whole society as well. We are keen to discuss the issue as little attention has been made to the fisherman's case. The prosecution of the Chinese fishermen has raised concern over the existence of the Acehnese tradition of rescuing the people in distress at sea. As we have distinguished speakers this evening, this discussion will propose avenues for the betterment of the fishermen, Chinese tradition, and refugee protection in Indonesia. Thank you, distinguished speakers and our participants, for your participation. And I wish you an engaging and interesting seminar. Thank you very much again. Hasbunallah wa ni'mal wakil. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you to Dean Faculty of Sharia and Law, Dr. Haji Ahmad Talabi Kharli SMA, who just delivered his opening remarks. And ladies and gentlemen, let's come to another agenda for this evening. I would like to inform you that we have 4 speakers tonight. The first speaker is Heru Susetyo, SH LLM, MSc, PhD. The topic is there any chance of discharging the Acehnese fishermen who rescue the Rohingya refugees? And the second speaker is Professor Ancha Misbah, PhD. She will talk about understanding the case of people smuggling in Indonesia. The third speaker is Dr. M. Adli Abdullah. We'll talk about legal pluralism in Aceh, the role of Adat Laut in Aceh. And the fourth speaker is Martin Jones, who will talk about the Convicting Acehnese Fishermen International Refugee Law Perspective. And this seminar will be led by Fitria SHMR, PhD. Time is yours.
Thank you so much, Dr. Mashrofah. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Honorable Professor Dr. Amnil Bis, Dr. Ahmad Talabi, Dr. Charul Adam, distinguished speakers, dear colleagues, students, and all the participants. Assalamualaikum warahmatullahi wabarakatuh. It's a great pleasure for me to moderate these interesting and very important topics. And it's a bit unusual to hold a seminar in the evening. But despite the fasting months, we can drink coffee and tea so whilst attending this seminar. I think as we know that, as we heard from our dean, that he has highlighted that the punishment which is imposed on the 3 fishermen received little attention from academics and the media. Fishermen used to be framed as heroes, as we know that what was happening in 2015, and also as rescuers, of course. But now it seems that they have been also framed as smugglers, as 3 fishermen received money as compensation for their help to Rohingya refugees. So for this reason, they are sentenced to 5 years in jail. Sorry, would you please minta tolong di mute? Yeah, thank you. So I continue the little bit more the introduction. So for this reason, they are sentenced until 5 years in jail. So do they deserve to be called as smugglers and be sentenced to 5 years? If not, what efforts that we can do to release or if not decrease the judgment? So we are happy to have 4 distinguished speakers with us. Professor Ance, Pak Heru, Mr. Martin, Mr. Adli, and I think I will begin first to Pak Heru to let Pak Heru say about this. But I would like first introduce Mr. Heru Susetio a little bit about his CV. So Mr. Heru Susetio earned a Bachelor of Law from Faculty of Law, University of Indonesia, Master of Law in International Human Rights from Northwestern Law School, Chicago, USA, and also degree in Human Rights and Peace Study at Mahidol University, Bangkok, Thailand. Mr. Heru also was granted the most productive scholar from the Faculty of Law, University of Indonesia last year, and has written extensive books and journals articles. Interestingly, he is also an advocate, and one of the cases that he is involved in is this fisherman's case. Since we are very grateful to have him with us this evening, and to know better about the case and to get updated the case, I invite Mr. Heru to speak first. And Pak Heru, the floor is yours, please.
Okay. Terima kasih. Thank you so much, Dr. Fitria. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And so peace will be for all of us, hopefully, inshallah. And good evening or good afternoon, so good mornings, depend where we are. And Honorable Dean, Bapak Dr. Tolabi Kharli, also the moderator, Ibu Dr. Masrofa, and my dear colleague, Professor Ance Misbah from Germany, and Professor Martin Jones from UK, from Canada. And also my dear colleagues and also participant from UIN, from student or lecturer or researcher or any observer of these refugee issues. Thank you so much for giving me opportunity to share my experience and knowledge on refugee problem in Indonesia, particularly in the case of the 3 fishermen in Aceh. Actually, the case took place like 2 years ago in 2020, and the trial actually was last year and also this year. Last year for in the first court or Pengadilan Negeri, and then followed by Pengadilan Tinggi or High Court, and then Supreme Court decision is this year, just last month in March 2022. Okay, please let me share my PowerPoint. So, Ibu Fitria, as a moderator, thank you for actually giving us a very interesting issue, actually, the convicting Acehnese fishermen who rescued the Rohingya refugees, a setback for refugee protection in Indonesia. It's interesting because actually the case involving refugees, or involving the fishermen, not just 2 years ago, but I think from the last 2 decades in Indonesia. I believe that Prof. Ance has conducted a lot of research about this, not just in Aceh, but also all over Indonesia. I saw and I read the book of Prof. Ance, and Transit Migrant, something, I forgot the title. And actually, about this case, the timeline actually started in June 2020, where at that time there were 99 Rohingya refugee people stranded on Lancok Beach, Samtalira, Bayu District, North Aceh. So almost 2 years ago. And a number of fishermen and residents helped unload them, including the 3 fishermen, namely Abdul Aziz, Faisal Afrijal, and Afrijal alias Raja. The refugees were accommodated in the former Lok Sumawe Immigration Office, and then all of them underwent an antigen test, and the result were negative for COVID-19. Because at the time, still Indonesia has been attacked of not just Indonesia, I think all over the world by COVID-19 in March 2020. And 2 days after that, the Minister of Foreign Affairs, Ibu Retno Marsudi, issued a press release to investigate the alleged element of people smuggling and human trafficking in the incident, because it was reported that about 15 other people were reported to have died while at the sea. And followed in the July, August, September, the police began to investigate the alleged smuggling of the Rohingya, and this Red Crescent, or the special crime police investigator of the Aceh police, has started the investigation. And finally, on October 27, 2020, the Aceh Regional Police, or Polda Aceh, revealed that as many as 99 Rohingya immigrants who were stranded in Aceh on June 24 were apparently deliberately smuggled by a people smuggling syndicate group, which has now been secured at the Aceh police headquarters. And the suspect there are 4 suspects, namely 3 North Acehnese people, namely the Abdul Aziz, Faisal Afrijal, Afrijal alias Raja, all of the are fishermen, and 1 Rohingya resident, namely Sahaddin. He lived in, I think, in Medan in North Sumatra. The 4 are suspected of being a people smuggling syndicate. And the case actually was brought to the court, to the district court of Lok Sukon, is around Lok Sumawe. The panel of judges at the Lok Sukon district court not actually sentenced the 4 smugglers to 5 years in prison each for all of them. They were also fined 500 million rupiah or 500 juta rupiah for being proven to have smuggled dozens of Rohingya into Indonesian water via North Aceh. Their verdict was read out separately by the panel of judges. Abdul Aziz, Faisal Afrijal, and Afrijal alias Raja had their verdict read on Monday, 14th of June 2021. And so there are several persons involved. Salim bin Suhaimi, suspected of bringing the Rohingya out of the BLK, Balai Latihan Kerja, or the special vocational center, the training center, Kandang refugee camp. However, the act did not work. So this is like in recent language, is percobaan, or just a trial, not a complete crime, but just a trial, a percobaan. And decided at the Lok Sumawe District Court with 5 years in prison for people smuggling charges. And the appeal, actually, there are some legal counsel involved to represent the convicted person, including actually my dear colleagues from Paham or from Piara in Lok Sumawe, and also in Benar Meriah in Gayo. They represented the fishermen from actually since the district court up to high court and then to Supreme Court. And I need to appreciate the involvement of my colleagues like Ibu Nikmah, and then other colleagues from Legal Aid Center of Paham in Aceh. And they told us that the appeal efforts to the High Court in Banda Aceh was finally rejected, and also the cassation or the kasasi at the Supreme Court or Mahkamah Agung has also been rejected this year. And the second person is Sahaddin bin Ashraf Mia. He is a Rohingya, suspected of. Actually, Sahaddin arrived to Indonesia in 2011, if I'm not mistaken, but I read the case of him. He stayed in Medan city, and he came to Indonesia in 2011, and he was suspected of bringing 99 Rohingya into Indonesian waters, and he was sentenced in the Lok Sukon District Court for 5 years in prison, and in High Court it was also confirmed the same sentence, like 5 years in imprisonment. And finally, also when he brought the case to Supreme Court, also rejected by the Supreme Court. And the other are 3 fishermen on Nelayan Aceh, fishermen on Nelayan Aceh, who helped the Rohingya asylum seekers. The case is almost the same with Sahaddin. They were sentenced to 5 years imprisonment at the Lok Sukon District Court, and the appeal was upheld by High Court of Banda Aceh, and the cassation or the appeal to Supreme Court also rejected. Faisal and Afrizal Raja signed the verdict execution for Aziz, who is being held in Calang area in the western part of Aceh province. There is no decision on the cassation yet until the case until today, but we still wait. Actually, what is the main charge or the main indictment of the 3 fishermen? Actually, the article 120 120.1 on the law number 6 2011 on immigration. So the judge, so the police as well as the prosecutor and also the judge, they use this article 120.1 on the law on immigration number 6 2011 for indicting the 3 fishermen, also for Sahaddin. And it is mentioned that everyone who commits an act that aims to seek profit either directly or indirectly for themselves or for others by bringing someone or group of people, both organized and disorganized, or order others to bring a person or group of people, either organized or unorganized, who do not have the legal right to enter in this territory or out of the nation territory and or enter the territory of another country, which has no right to enter the territory legally, either by using valid documents or fake documents, or without using travel documents at all, either through immigration check or not, shall be punished for people smuggling with imprisonment of a minimum of 5 years and maximum of 15 years, and a minimum fine of 500 million rupiah and a maximum of 1.5 billion, 1.5 billion rupiah. An attempt to commit a crime, people smuggling, is punishable by crime law, the same as referred to in paragraph 1. So, all of them actually were charged with this article number 120 from the law number 6 2011 by committing an act that aim to seek profit directly or indirectly. People smuggling charge, people smuggling, and the attempt to commit a crime of people smuggling or percobaan untuk menyelundupkan manusia is so punishable by criminal law, the same as referred to in paragraph 1, almost similar. So the attempt to commit a crime and the real crime was charged similarly. And here is the summary of the verdict of Lok Sukon District Court. Declared that the defendants are legally and convincingly proven guilty of committing the crime of people smuggling as stated in the single indictment and or dakwaan tunggal, right? And sentencing the defendant with imprisonment of 4 to 5 years and a fine of 500 million rupiah, provided that if the fine is not paid, it is replaced with imprisonment for 1 month. And determined that the period of arrest and detention that has been served by a defendant to be deducted entirely from the sentence imposed, or in Indonesian language is pengurangan masa tahanan, right? And determine that defendant remains in custody, determine that the amount of evidence to be confiscated or destroyed, and to charge defendant to pay court fees in the amount of 5,000 rupiah. Very small amount of money, or very murah actually, very cheap, just 5,000. 5,000 euro, $5,000 is a lot, but 5,000 rupiah is nothing actually, just only 5,000 rupiah. We cannot buy anything with 5,000 rupiah. Only warung Tegal, masih nasi at warung Tegal. And the defense, and what is the defense? The defense from the defendants, the 3 fishermen, they defended their position by saying that we are not the main perpetrator, we are not the planner, we are not, or in Indonesian criminal law is we are just like penyertaan, like accomplices. We are not the main perpetrator, we are not the planner, we are the man behind the gun. We are just helping people by following the order from Sahaddin, Anwar, and also Adi Jawa. They said that at their defense that Mr. Adi Jawa, Anwar, and Sahaddin bin Afsramiyah ordered or persuaded defendants to use means and effort to pick up a group of 99 Rohingya asylum seekers from the sea to the land, from the high sea to Aceh, Aceh coastline. That there are 3 defendants, namely Faisal, Afridal, and Abdul Aziz, whereas the planning to pick up the Rohingya asylum seeker, which consisted of 99 people, was carefully prepared by Adi Jawa, Mr. Anwar, and Sahaddin as the main perpetrator actually. And in preparing a plan to form cooperation to commit a crime, the 3 main actors did not involve the defendants Faisal, Abdul Aziz, and Afridal. So the positions are different between Anwar, Adi, and Shahad with these 3 fishermen. And so here is their defense, that they believe that they do that because of they would like to take the wages or some money from from Adi Anwar, from Adi Jawa and Anwar and Sahaddin, and they try to locate the Rohingya people at the axis of people in the middle of the sea by using the coordinates given by Anwar to locate or to the coordinate of the Rohingya boat. Okay, actually, this is an unfinished job because the defendants have failed to land 99 Rohingya people in Aceh seashore. The boat people are brought into Indonesian territory by other fishermen from 50 miles or at 75 miles, or still in high seas or in international waters, not in Indonesian waters. Actually, according to international law, is 12 miles. So actually, this is unfinished job because the boat got the problem, the engine problem, engine error. So then another fisherman helped by the Indonesian Maritime and Air Police and the local government ship or Muspida helped the Rohingya boat people to land to Aceh land actually. So there are some legal debate as well. International law recognizes the right of everyone to leave the country in which they live out of reasonable fear on the grounds of race, ethnicity, religion, nationality, membership of particular social group, and different political opinion. And also there are customary international law that recognize the principle of non-refoulement or prohibits each country from returning or expelling refugees to their country of origin or territory where refugees will be faced with things that can threaten their safety and life. And Malaysia is a country that has consistently implemented customary international law, as evidenced by accepting and allowing Rohingya refugees to stay temporarily. Temporary means unclear or indefinite times, because I met some Rohingya people in Medan, in Pekanbaru, in Riau, and even in Ciputat just 3 days ago. They have lived here for 10 years. Another for 15 years, another people for 18th year. They have lived in Medan or in Jakarta or in Makassar or in other places in Indonesia, the Rohingya people. But temporary means an indefinite time. Nobody knows for how long they can stay here. Yeah, if we meet them in Aceh or in Medan, some of them are still there, some of them were disappear, travel everywhere, but still in the country, or they return to Malaysia through just crossing the Malacca Strait, but without being recognized by immigration or by Indonesian Navy. So yeah, or we call it as jalan tikus, or the red, actually the illegal road. And we have Residual Decree number 125, 2016. Actually, this is like the temporary mechanism, not the complete and final and binding mechanism, but at least Indonesia has this mechanism. And it's quite, I can say this is like alternative to save and to work to save the refugees in this region. And even though it concerned only with to handle the refugees from the overseas, to how to help, how to search for, to help, to save and evacuate when they were in emergencies or dangers. So but this decree doesn't deal with other things, with other rights of refugees about nationality, concerning their prosperity or their future status. Actually, is not part of the decree provision actually. But at least Indonesia has this regulation, this presidential decree. And Indonesia has also ratified the UNCLOS, the UN Convention on the Law of the Sea, but with the law number 17, 1985, it's mentioned in the Article 98 of UNCLOS that there is a duty to render assistance. Every state shall require the master of a ship flying its flag insofar as he can do so without serious danger to the passenger, to render assistance to any person found at the sea in danger of being lost, to proceed with all possible speed to the rescue of person in distress, it involved blah blah blah. And actually, yeah, there are another law like this in UNCLOS. So actually, there's some other mechanism in international mechanism. And my last presentation, actually, I like to wrap up that the clear problem of the conviction of the 3 fishermen are because they are, let's say, like the vacuum of national legal framework in dealing with refugees or in dealing with asylum seekers, in dealing with transit migrants. And because the country hasn't ratified the 1951 Refugee Convention, and it has no law or undang-undang concerning the refugees. It has only the law on immigration in 2011 and the law on hubungan internasional or hubungan luar negeri or foreign relationship in 1999, but it didn't clearly mention about refugees. And there are some surat putusan Dirjen Imigrasi or Director General of Immigration decree about how to handle refugees. So in general, there are no clear framework and complete framework about how to deal with the refugees. There is only immigration framework, not a refugees framework. So when it comes to the case with involving these 3 fishermen, so the court deal only with this is people smuggling, not another kind of saving the life of refugees, because they clearly convinced that the people smuggling activities took place in 2 years ago in Aceh. So it meets with the article of 120, the law number 6, 2011. So here is the problem, and perhaps in the near future, if the country hasn't ratified or hasn't enacted another law which clearly regulate or dealing with the refugees, and we will see another problem like this in the near future. As long as I observe, because this is like a good place for transit migrants because it has very long coastline. It's very many islands, 17,000 islands, and like in the crossroad between Southeast Asia and with Australia, with the Pacific and with the Indian Sea. So it's quite a good place for transit migrant and for the boat people. I would like to end my presentation. Thank you so much for listening to me, and we hope that we will have a very good and fruitful discussion. Terima kasih. Thank you so much, and wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Very, very, very interesting presentation indeed. So thank you so much, Pak Heru Sesetio. And you have, pointed out very important, key, aspects of the case. And I think, as you said, that this is ongoing process. I mean, at least we still have like judicial review. We still have one more chance to kind of battle this, to fight for the fishermen, as they are all besides one Abdul Aziz, but the rest already convicted in the Supreme Court. level, but we still have one more chance for judicial review. And Pak Heru has highlighted about the overlapping, like regulations, and the question what should what law should override the rest. But it seems that the governments or the court, has override the immigration law offers any others law as such as international law or international customary laws. And I will now move to the second presenters. We have I'm very happy for having Professor Ance Misbah. So I will point out her CV to make us more familiar with her. She accomplished her PhD from the Australian National University, Canberra, and Professor Ance is very productive author, and she has written many journals, articles, and books, and her research interests including the socio-legal dimensions of forced migration in Southeast Asia, border regimes, asylum policy, refugee protection in the Asia Pacific. As I said, she has written extensive papers and journal articles. And one thing about the people smugglers in Indonesia, and I read about her book on the policy paper titled "Trials of People Smugglers in Indonesia, 2007 until 2012." She observed about 45 cases within 5 years, and only one case found the accused unguilty. So hopefully, Professor Ance will tell us about this, and then maybe give a suggestion, especially for the Pak Heru and the advocates, what arguments can be used maybe by the advocate to win the next battle as the last resort, which is judicial review. Professor Ance Misbah, the floor is yours, please.
Okay, well, thank you very much for the invitation. I'm very happy to talk to you. So, selamat malam di Jakarta and salam from Bielefeld. I thought that I would briefly compare the case of the Acehnese fishermen with the general developments of how people smuggling has been dealt with in Indonesia. Because what we have seen before 2011 is that there has been a lot of ignorance of this kind of irregular migration in Indonesia, but because of substantial pressure from Australia, Indonesia decided to criminalize the act of people smuggling. So people who assist others to come into Indonesia or to leave from Indonesia are now being called people smugglers. So for the last 10 years, I've been looking at two questions. First of all, who are those smugglers? What kind of people become involved in bringing refugees, asylum seekers into Indonesia or out of Indonesia? But then also I was interested, who is actually going to jail? And you will see these questions are connected, but there's quite a bit of a difference here. Today, in theory, my new book about decriminalization of people smuggling was published. I haven't actually checked with the publisher, but it was set to come out today. Now, in many cases, we will see that the way the Acehnese fishermen have been treated are an exemption, and I will tell you why. Back in 2011, when I started looking at people smuggling cases in Indonesia, you will see that it was always about leaving Indonesia. Like this was the main concern of the law enforcement. They wanted to stop asylum seekers from going to Australia. And you see that there were two specific places, Ashmore and Christmas Islands, where asylum seeker boats went to. Now, I looked at a number of cases between 2011 and 2015 to see where did the trials actually take place. And as you can see, most of the cases were actually in Java. This was the main departure point. You see there's no case in Aceh at all at around this time. Primarily, the police and the immigration was interested in arresting people who were trying to take asylum seekers out of Indonesia. only a few cases where they were bringing asylum seekers into Indonesia, and this is the area around Batam. In my research, I was of course interested to see like these people smugglers, where are they actually from? And not only did most of the cases take place in Java, in fact, most of the people who were prosecuted, they were also Javanese. So that's not too surprising because Java is the most populated place in Indonesia. So that's of course reflected here. Nobody from Aceh was involved until 2016. When we look at the occupations of those people who have been sent to jail for people smuggling, we see that there's a lot of fishermen, and that's not too surprising because fishermen, of course, bring the skills that are required to transport people by boat over long distances. But the second largest group, as you can see here, are actually self-employed people. Now, self-employed often is a euphemism for people who don't have stable jobs. So these are the poorest of the poor who often are not counted as jobless or unemployed, but rather as like having this kind of casual employment. So people who are in an economic unstable situation are, of course, much more vulnerable to being recruited into what is loosely described as the offense of people smuggling. And the same, in a way, also counts true for fishermen, because those are the people who have very precarious lives. They earn very little, and in a way, they're more open to this kind of offers by recruiters. Now, the last slide that I want to show you here is like, when it comes to fulfilling certain tasks within the people smuggling, we will see that the largest people who went to jail were drivers. So people who drove asylum seekers to the beach. And you will be a bit surprised, how is this possible? Wouldn't we rather expect the boat crew to be the ones who go to jail? Well, not necessarily, because most of the arrests in Indonesia are taking place on land. There is not enough capacity amongst the maritime police to control the Indonesian waters. So the only chance usually to arrest people is when they are driven by car to the beaches. And that's why we see a high number of drivers rather than actual maritime transporters going to jail. Now, I don't really have to talk so much about the case. Pajero has explained sufficiently what has been going on, and this was very interesting. I didn't know that the Mahkamah Agung had already made most of the decisions. Well, maybe a few words about the Rohingya. Most of you are aware that these are often described as the world's most persecuted minority. There are Muslim people from Myanmar, and in 2017 we have seen an enormous forced displacement. When we look at where Rohingya people live, we can see that most of them have gone to Bangladesh these days. There are also Rohingya diasporas in Saudi Arabia, Pakistan, but Malaysia has increasingly become an place where the Rohingya would like to go to. And that's not just because Malaysia is also a Muslim country and therefore an attractive destination, but it's also Malaysia is economically quite attractive to Rohingya. By now, there are about 150,000 Rohingya already living in Malaysia, and it is estimated that since 2012, about 100,000 have come to Malaysia. So there's a lot of like chain migration happening here. Malaysia has very different ways of dealing with Rohingya or any other irregular migrant. At times of economic prosperity, they are very keen to get cheap labor. In times of economic downfall, they're often trying to get rid of this kind of cheap labor. How are people traveling to Malaysia? Now, there are basically two main routes. Either people go across land, which means from Myanmar into Thailand and then to Malaysia, but increasingly they have also used the maritime routes. And the reason why we can see both routes is that sometimes there is quite substantial border patrol happening at sea. That means more people would then choose to travel by land. Sometimes there is more border enforcement at land, and people then would, of course, go by sea. Now, some of you probably remember that in 2015, there were some very grim discovery made in Malaysia and in Thailand, where hundreds of dead bodies were found in mass graves. And these people were suspected to be Rohingya who had been held at ransom by traffickers, and they were trying to squeeze out, to extort more money from them. So they prevented them from moving on to Malaysia because they wanted to make more money. When those mass graves were discovered, what happened is that a lot of smugglers, traffickers put all the remaining Rohingya on boats and sent them out to sea. They basically abandoned the Rohingya in the middle of the Andaman Sea, and people were drifting for weeks without any support. It was only at the end of May that Malaysia, Thailand, and Indonesia agreed to allow these people come to land in order to save lives. Now, this Andaman Sea crisis back in 2015 caused quite substantial outcry in the international world. And Thailand and Malaysia, they kind of were forced to do something about this transport of Rohingya people. And what we can see is that there were a number of trials that happened both in Thailand and Malaysia. In Thailand, more than 100 suspects, including some senior Thai government officials who have actually been involved in this kind of human trafficking, went to court. Some of them were convicted, and the jail terms that they received were quite high. Some of them went to prison for 78 years. So that's substantial. So Thailand was really keen to do something because they were very much afraid that their international reputation would suffer if they were not doing something about it. Malaysia, well, there were only 10 people who were, had to go to jail, and those people were all foreigners, Thai people, Bangladeshi, people from Myanmar. Not a single Malaysian police officer was punished, even though there were substantial suspicions that they were also involved in this kind of international trafficking. The interesting thing is that in Indonesia back then, 2015, 2016, nobody was punished for smuggling or trafficking Rohingya people into Indonesia, even though since 2009 onwards, we have seen smaller cohorts of Rohingya coming to Indonesia. And some of them, of course, had also been assisted by Acehnese fishermen who brought them to land, to the shore, against the orders of the Indonesian authorities. Now, again, I don't have to talk so much about the trial of the fishermen because luckily Mas Heru has already done this. But I would like to point out to one fact, which is what actually happens to the rescued Rohingya. Now, many of you will know that they only stay in Aceh for a short term. The majority of them actually wants to move on to Malaysia. This is where their family is waiting for them, and this is where they want to go. Chances for them to find work in Malaysia are higher than in Indonesia. In order to leave from Aceh, they once again will have to make use of transported facilitators, smugglers, whatever you would like to call these people, because this is where they actually want to be. Now, maybe just to summarize some of my main findings is that when looking at the specific case that took place in Aceh in 2020, the case of the 3 Acehnese fishermen who have been punished for people smuggling clearly shows that the law enforcement authorities, they really ignore the complex patterns and the history of the secondary movement of Rohingya refugees They do not look at the complexity and the pressure that these Rohingya people are under. They only choose one tiny segment, which is the transport of those people into Indonesia. Because people smuggling in Indonesia is becoming a bit more politicized, there is a certain pressure to arrest people and punish people. And the easiest target for these punishments are actually fishermen. But in a way, this is not going to change any of this problem that Rohingya will have to find safe places to live, because neither Myanmar is safe for them, nor is Bangladesh. Well, as a final question, and that's maybe something we can do look at in the discussion, is the case in Indonesia unique, like punishing rescuers, punishing saviors? Is this something that only happens in Indonesia? Well, actually, it's not. When we compare this case from Indonesia to what, for example, is happening in Europe, we can see that there is this tendency of to criminalize solidarity. Similar to fishermen in Aceh, we have seen that dozens of fishermen in the Mediterranean Sea has been arrested and taken to court. Similarly, we can also see that a lot of NGOs that are trying to save stranded asylum seekers in the Mediterranean are now being criminalized. And on top of this, we can even see that the authorities are even to punish migrants themselves for the act of smuggling. So in general, we can say that the criminalization of solidarity is unfortunately a global trend that can be observed. All right. Well, thank you for your attention, and I'm looking forward to the questions later on.
Thank you very much, Professor Anja. Very, very, very interesting points that you have highlighted. So it was not to bring in, but it was to bring out to Indonesia, to Australia. This is the first, like if you see, so the history of the people smuggling, as the Professor Anja has highlighted, but the things that it's not specifically Indonesia, but it happened anywhere, and even in Europe, criminalization of the solidarity has rise, and even the migrants themselves. But I think the things that we have to more elaborate later is about how to show the complexity of the the problems, and it's not only about the transport of these people, but also we have to kind of show to the authorities, to the courts about we have to see this case more in the broader context, in the broader perspective. So for that, maybe we can have like more change to get the fishermen, if not released, maybe can decrease their punishment. But okay, I will move to the next speakers. I was Dr. Adli. Adli, are you there? I call him. He said he is still on the way. Maybe I will go first to Mr. Martin Jones while waiting to him. So the same like the two others speakers, I will briefly read the CVs of Mr. Jones. Mr. Jones, Martin received his degree both in history and law from the University of Queens and University of British Columbia in Canada, both of the universities. And before his academic positions, Martin practiced refugee law in Vancouver, and he continues also to work closely with legal practitioners, particularly providers of the refugee legal aid in the Global South. He was a founding member of the chair of the Southern Refugee Legal Aid Network and founding the chairs of the Legal Aid Working Group of the Asia Pacific Refugee Right Network. Before joining the University of York, UK, he held various visiting positions at Georgetown University, University of Michigan, the American University in Cairo, and the University of Melbourne, Australia. And he is currently also the visiting associate professor at the University of Hong Kong. Martin, yeah, I think you can give us more perspective of international law, how international law see this case, and maybe you can also like give your recent I think research about what is going on in Aceh. And okay, I think I will not be too long, and just want to give the chance to you, please, Martin. Time is yours.
Thank you so much, Fitria. And I want to echo the thanks of other participants already to you personally for organizing us today, to your university and the center that you lead for bringing us together. I think it's, as others have pointed out, a really important moment for us to reflect and to talk about these developments. And I think it's really useful to think about the situation from the multiple points of view that we're already beginning to hear from within the cases themselves, as well as what Anjay's just sketched out, the broader context of prosecutions of trafficking and smuggling within Indonesia. I want to continue kind of bringing a slightly different lens to the problem and look at this in a sense from the point of view of, in particular, the international refugee regime, but kind of some of the other international issues that it raises. And as Fitria has alluded to, I mean, I think as with probably everybody else on this meeting in this workshop, I followed with great interest the developments in Aceh. I mean, since we conventionally date it to 2009, probably since before 2009, even with the rescues certainly culminating in the most famous rescues of 2015. And I think this case continues a really important pattern of developments in Aceh, which I think raises some fundamental questions about how we understand refugee protection that I'm going to try and circle back to at the end of my presentation. I suppose the final thing to say by way of introduction is it strikes me as a particularly opportune moment to talk about this case. Not just because of the Supreme Court decisions that are out or about to come out, but also kind of in this month where we say Ramadan Kareem. It strikes me as a useful moment to reflect upon, as Anjay has talked about previously in some of her writings, kind of the limits of our generosity, it would seem. So what I would like to do is really sketch a bit of the broader context in three different ways. First, to try and link what's happening in Aceh with what is happening elsewhere, and this has already been mentioned. I think there's a pattern that we need to understand in order to really kind of get a sense of what's going on in Aceh with these prosecutions. I want to then also ask, what does the international refugee regime have to say about rescue? And the hint here is probably not enough. And then finally, use this international lens to make some reflections on the limits of our obligation, the nature of obligation, as well as the role of rescue within obligation. And really in the closing part, to probably ask more questions than I answer, but perhaps it'll be a useful way to bring us into the discussion that follows, which I'm looking forward to. A few words of background to begin with. I suppose the first is to observe that this movement of people seeking asylum, refugees by sea, is not a new phenomena, nor is it a phenomena that is kind of centered on the Andaman Sea. Refugees move. It is one of their defining features that they have moved from their country of nationality or their place of former habitual residence somewhere else. And often this movement, as with human movement more generally, happens by sea. Famously, within the region, we had the Indo-Chinese, the so-called boat people, moving throughout the region, including to Indonesia, but also Malaysia and Hong Kong, Philippines, I mean, scattered throughout East and Southeast Asia. But this is movement that happens around the world. It happened across the Caribbean in the 80s with the Haitians. It continues to happen, although less now, across the Gulf of Aden, either from Yemen now or to Yemen from Somalia previously. It has happened for many years across the Mediterranean, first the West, then the Middle, and now the Eastern Mediterranean. And it happens across the English Channel between continental Europe and the United Kingdom. And in all of these cases, it attracts both attention as well as often quite drastic policy responses, some of which seem to be mediated or encouraged by the fact that these are distant places. I suppose the final example is one closer to home, obviously, that has already been talked about, which is the kind of, in a sense, the migration through Indonesia previously to Australia, and Australia's infamous efforts to deter and interdict that movement. And this raises some fundamental challenges of dealing with our obligations to, broadly speaking, people on the move, including refugees. It raises questions about the extraterritorial nature of our obligations, kind of where do states' obligations begin and end, and the extent to which kind of the limits of the foundational principle of refugee law and refugee protection, which is non-refoulement, or not sending people back to danger. And to what extent, I guess it raises the question of to what extent is not letting people in, sending them back. So I said that's broader context. I said I wanted to begin with some comments linking the prosecutions with activism, rescue, and broadly speaking, the global phenomena of shrinking civic space. This, as Anjay mentioned a moment ago, is not the only prosecution of rescuers, if we can use that term broadly. We have, in recent years, seen the prosecution of captains and crew of rescue vessels, most famously the Juventa in Italy in August 2017. More recently and ongoing, the prosecutions in Greece of Sean Binder and Sarah Mardini. Sarah Mardini herself, a refugee, competitive swimmer, participating in the ECRI's rescue efforts in the Eastern Mediterranean and continuing to face detention. I think she's now out of jail, but prosecution along with her colleague Sean. Perhaps kind of extending the boundaries of what we mean by rescue, the prosecution of Helena Maleno by both Spain and Morocco, a human rights defender based in Morocco, who helped coordinate the rescue, not rescued herself, but coordinated the rescue of migrants crossing the Western Mediterranean, the Straits of Gibraltar, credited by government officials with helping rescue more than 10,000 individuals over an extended period of time crossing the Gibraltar Straits, but attempted prosecuted by both Spain and Morocco before more recently she was deported from Morocco. And I suppose the broader tradition, inglorious that it is, that we have within refugee protection of prosecuting rescuers, or those who help with individuals gaining sanctuary. And we think often of rescue as happening, in this context on the high seas, but what about rescue by providing safe passage through dangerous countries to safety? The so-called underground railways, including the underground railway that exists today in the region between North Korea through China to places like Thailand and eventually South Korea. But going back to the 80s, we have prosecutions in the U.S. of religious officials, religious members of religious orders, and lay volunteers within those orders, of individuals operating the Underground Railway, 20th century version of the Underground Railway, helping Central Americans flee Central America across the US and seek sanctuary, usually successfully, in Canada. So there is a broader historical trend of states using these prosecutions to both deter activism in the sense of criticism of its own policies, as well as to try and stop movement, to increase, in the sense, the costs of movement. Bluntly, by increasing the risks associated with movement. And the other aspect of the international context is the observation of the United Nations Special Rapporteur on the situation of human rights offenders, that activism in aid of those seeking sanctuary, as well as other people on the move, is increasingly difficult. He noted in his 2018 report to the Human Rights Council that, the international community was galvanized by the body of Aryan Kurdi washing ashore, the photographs of the body washing ashore in Greece, and recommitted itself to refugee protection, including rescue and safe migration. It articulated this new commitment in the New York Declaration. It then negotiated both the Global Compact on Migration and the Global Compact on Refugees, all three of which were supposed to reaffirm and support greater protection of people in vulnerable situations, kind of moving between countries. He wrote his report in 2018, and he noted that despite this renewed commitment, individuals, groups, and communities defending the rights of people on the move have faced immense challenges. Defenders of people on the move face unprecedented restrictions, including threats, violence, denunciation, and public discourse, and, as we see in this case, criminalization. Which is part of a broader trend of activism becoming more difficult. As Mina Kiai wrote, he was previously the Special Rapporteur on freedom of association and peaceful assembly. It's almost passé these days, as depressing as it sounds, to declare that civic space is shrinking across the globe. Indeed, the trend is so common and it's spread to so many countries that it risks becoming the new norm. We're on the precipice of an era where countries will be bold in their repression, leaving ordinary people meek in asserting their rights. He describes this as an existential crisis, that without the ability to be active and to campaign and to advocate about policies, in a sense, the life of certainly liberal democracies disappears. And the global context is unfortunately also the Indonesian context. I don't need to tell you all, most of whom are in Indonesia, about the challenges facing activists within Indonesia. As the Special Rapporteur, again, on the situation of human rights offenders, wrote in his World Report, and the entry on Indonesia, somewhat presciently perhaps in 2018, human rights offenders in Aceh continue to face high risks. Impunity for threats and attacks against human rights offenders persists. The criminalization of human rights offenders has been a worrying trend in Indonesia, as has been the amendment and introduction of laws that further restrict rights and freedoms. Now, obviously, one of the threshold issues is the extent to which we understand these individuals who have been convicted of smuggling as human rights defenders. I suppose what I would say to that question is, if we look at the UN's own definition of human rights defenders, it is a very broad and all-encompassing definition. And that certainly when we broaden the scope to look beyond these three particular cases, I think there's no question that the fishermen and the broader fishing communities, including the Penglima Laut in Aceh, would easily fall within the UN's definition of human rights event. So this is all to say that kind of what we're seeing with these prosecutions, in a sense, has resonances with prosecutions elsewhere, that this is, in a sense, a tactic of the state, as well as part of a worrying trend that should concern even those who aren't particularly concerned about how refugees or migrants or other groups of people are being treated. So that was the first observation I wanted to make. I recognize I'm using up your time, and so I'll try and make my next two parts of my presentation briefer. I should say something about the link between the actions of these individuals, as well as the fishermen, and refugee protection more generally. And the starting point for the international conversation about refugee protection is the Refugee Convention and the associated international refugee regime led by United Nations High Commissioner for Refugees, UNHCR. And the Refugee Convention, somewhat ironically, given the predicament we find ourselves in with the Rohingya getting stuck in the Andaman Sea and different states disavowing obligations towards them and then seeking to prosecute those that would bring them ashore, is the kind of the starting point of the refugee regime is exactly this problem. The recognition that asylum can be difficult, the granting of asylum, and that international cooperation is needed. Now, it's an interesting observation, perhaps, to talk about refugee protection in Indonesia, because as we know, Indonesia is not a party to the Refugee Convention, nor are most, particularly Southeast Asian states, Cambodia being the only, Cambodia, and depending upon how you define the region, Timor-Leste being the only possible, will be the only exceptions. But if we look more broadly at the regime, including the customary norms that bind states, that even states that aren't party to the refugee regime, we see that it generally only that it imposes obligations on states towards refugees that they have some level of attachment to. And we see this in the Refugee Convention explicitly, but it's also more generally true of other obligations under customary law. And the problem here is that the sense of attachment is usually defined in terms of physical presence or legal status. And when we're talking about individuals on the high seas, they have neither. The Refugee Convention also recognizes the requirement that refugees oblige or act in conformity with local laws. And unfortunately is silent, I guess, on the broader issue of burden of responsibility sharing, which kind of can be understood in a sense as encouraging, or at least leaving open a range of developed policies by states to kind of externalize their borders and to kind of push refugees from coming ashore or from flying onto their territory so that they end up elsewhere. And that's the reality of refugee protection in the world. This is a kind of slightly manufactured list of the top refugee hosting countries, combining kind of recent developments in the Ukraine with the 2020 data. I think it's roughly accurate. But half the world's refugees, roughly half the world's refugees are hosted by these states that you see on your screen. And so an inordinate kind of burden or responsibility falls on a very tiny fraction, whether it's in terms of population or territory or economic resources of the world's international community. Now, part of the explanation for the concentration of refugees in limited numbers of countries is, well, there's, I guess, two possible explanations. One is the reality that the majority of the world's refugees, in fact, probably 3/4 of the world's refugees, are generated by about 6 different conflicts. Yeah, so when we talk about refugees, although that may generically mean kind of anybody fleeing persecution, the overwhelming majority of refugees in the world, 3/4 of refugees in the world, are fleeing some very specific civil wars, invasions, genocides in the case of Rohingya, and so on. A very limited number of these kind of extreme acts. And then the other part of it is, it becomes so difficult to travel internationally as a refugee or as somebody seeking sanctuary that they end up getting fixed in the most geographically accessible states, which are usually those states that share, in this case here, you'll see land borders, with one exception, obviously, with refugee-producing states. The Refugee Convention doesn't say much actually about the role of rescuers. And in fact, we'll see that the refugee regime has failed in its efforts to address the issue of rescue at sea more comprehensively. In fact, when it comes to refugees themselves, Article 31 of the Refugee Convention, which again, Indonesia hasn't become party to, only protects refugees in a fairly limited set of circumstances where they're coming directly from where their life or freedom was threatened. And this provision has been subject to a lot of judicial interpretation and is perhaps a bit broader than might be seen initially, but still is a fairly limited exception. I suppose it raises a fundamental question in terms of the refugees fleeing, Rohingya fleeing from Bangladesh towards Malaysia, coming ashore in Indonesia, about the extent to which the flight from Bangladesh is a flight from, in the language of the Refugee Convention, a place where freedom is threatened. I think this speaks to what Anjay has already sketched about the distribution of the Rohingya and also their situation in Bangladesh. And we can talk about it further in the conversation afterward, but my personal inclination is that yes, they would be, although certainly fleeing for a place where freedom is threatened, although perhaps not within the sense of Article 31. There is also a long international history predating the Refugee Convention of prohibiting disembarkation, including notably before the Second World War, of Jewish refugees fleeing the then Third Reich, the then emerging Third Reich, and rather circuitous, lengthy voyages across the Atlantic to the Caribbean and up the east coast of the U.S. and even Canada, with a ship in particular, the St. Louis, getting turned away repeatedly. So this is not the idea of trying to push, in a sense, interdict or push back boats is not a new one. And in this region, in Southeast Asia, it probably dates back most concretely to the famous case of the Tampa, which rescued migrants traveling from Indonesia towards Australia, and resulted in litigation in the Australian courts in 2001, with one of the rulings famously coming on a day that otherwise was marked for other reasons, September the 11th. More recently, interestingly, we have ongoing the prosecution actually of a government minister who refused boats coming ashore. In the case of Sicily, in Italy, Matteo Salvini, the former Minister of Interior, is currently being prosecuted for the crime of kidnapping and kind of illegal detention, I suppose, in terms of his actions preventing rescue boats coming ashore in Italy during his time as minister. And in the UK, there's currently debates in Parliament about the criminalization of rescuers in the English Channel, with attempts made by the government to criminalize the migrants themselves, as well as anyone who would rescue them. I said a moment ago that the refugee regime has tried to deal with this more thoroughly and has unfortunately failed. There was an effort in the middle of the last decade to negotiate more international guidance, which was pushed back with the rather kind of polite phrase that it's clear from the informal consultations and other dialogues that much further reflection remains necessary. in a sense, the state issue was whether refugee protection was the best way to understand rescue at sea, the point being made that there was another UN organization other than UNHCR, the International Maritime Organization, that should take the lead, which was an effort by states really to push the issue into the long grass, to give the issue from the UN's largest operational agency to one of its smallest. So I think one of the issues, and this Fitria mentioned this, that we have to contend with is how to frame this, the issue of rescue, or for that matter, kind of the acts that are happening in relation to the smuggling. Is this fundamentally a human rights issue? Is this an issue of maritime safety? Is this an issue of smuggling, trafficking, or is this an issue of refugee protection? I'll close with some reflections on obligation and rescue. And I suppose it's a question of the challenge of reconciling obligations. And I think in this case, we have competing obligations. The pluralistic legal regimes that exist, particularly in relation to Aceh, make it difficult even within the national legal system to kind of necessarily figure out exactly what duties and rights exist in relation to the rescue. But then we also have competing international regimes, and then the competition between the law and other senses of obligations, moral obligation or religious obligation in particular, the mandates of perhaps Sharia law, let alone faith or senses of humanity towards individuals in peril. And I guess the observation here in terms of how we go about reconciling these obligations is that what we've been talking about today is how the Supreme Court and various subsidiary courts reconcile these obligations. And I guess I would question the extent to which the legal profession and institutions are best placed to mediate between competing obligations. Clearly, that's part of its mandate, but lawyers and judges aren't necessarily best equipped to reconcile these competing obligations, or at least I would raise that as a question. The second challenge, I think, is the challenge of exceptional situations and kind of how we define them. You know, often we think of exceptional situations as defined by necessity and urgency. And I think in the case of that we're dealing with these three particular cases, beyond the broader issue of the rescue by the Acehnese fishermen, we have questions about the extent to which the manufacture of necessity or the manufacture of urgency, or for that matter, the financial gain by those involved in exceptional circumstances affects how we see them as being exceptional or not. Does the urgent need for rescue take people and actors outside of the normal frameworks of criminal law? Is there kind of, in a sense, a defense of necessity? And to what extent can you benefit from that defense if you've manufactured the situation or contributed to the situation in the first place? What extent can you benefit from that defense if you benefit more generally from the situation through financial payment, for example? And then finally, I guess we have the perpetual challenge of humanizing and localizing the law or obligation more generally. We often think about refugee law and refugee protection as belonging to the state. Certainly international law, including the refugee regime that I spoke of earlier, thinks about it this way. But which part of the state? Must refugee protection only be seen as national? Certainly we have a case within Indonesia of the Acehnese state, or at least traditional institutions within it, taking a role in refugee protection because of its particular constitutional settlement. But beyond the state, what's the role of the individual or the community within the state in seeking to fulfill obligations? To what extent can we as individuals or groups take on obligations that we see our state has failed in picking up? And so, as I said, I leave you less with answers and more with questions that I hope we can come back to and that I'd love to hear your responses to in the conversations that follow. So thank you for your patience, and I look forward to further discussion.
Thank you so much, Martin. Very, very rich presentation. I can, summarize because all of important things you have discovered, you have delivered. But the things that you have delivered, challenge of exceptional situations, these are the things that maybe the advocate should like elaborate more about the benefit that the fishermen gain, and from the the risk that they face when they rescue the Rohingya is also like should be a kind of deliver in the next things judicial review. And I think I will just move to the next, the last presenter. We have Dr. Adlin with us. Dr. Adlin, are you there? Dr. Adlin?
Yes, I am
Oh,
here.
yeah. Okay, thank you so much. I think I will highlight, some of the CV of your. There are a lot of things to be, tell, but I just mentioned some things that are very, very important. Dr. Adli Abdullah is a senior lecturer at the Syah Kuala University. It's not Syah Kuala University, Banda Aceh. He's lecturing on Adat Law, Islamic Law, and Aceh Studies, and he serves as an associate editor of Canon Journal. And the things which is very, very important that he also has written extensively on the Hukum Adat. He has made significant contribution to the preservation of Hukum Adat Laut and the role of Panglima Laut in Aceh. And I think it's very useful if we hear Mr. Adli talking about the role of Adat Law of the sea and in refugee protection, and it can also maybe be an argument for the advocate to convince the judge about the case, and I'll give the chance to Mr. Adli to deliver his ideas. Mr. Adli, the time is yours, please.
Okay, thank you. Can I share my?
Yes.
Let me.
Yes, please.
Okay. Thanks. I think good evening, everybody here, because some of you I know better, like Anchal Misbah, when she was did a research on diaspora of Aceh before, and then Martin Jones, me. Fitria just contact me this afternoon for sharing the ideas with everybody here concerning about the Panglima Laut and its adat practice by the Acehnese fishing community. Beside of that, I was worked with Panglima Laut as General Secretary for 10 years, since 2000 to 2010, and 2010 up now as the advisor for this group in Panglima Laut. But I also involved in for your right activists for Rohingya issues. I was elected as General Secretary for International Concern Group for Rohingya, ICGR, our home base in Bangkok. If we discuss about Panglima Laut, I think everybody knows that this traditional institution is called Adat Community. Already exists since the kingdom of Aceh before. Even though if you read the history, when Marco Polo traveling to Asia before, he met with Panglima Laut in 1292. When he stayed in Aceh for 6 months in Samudra Pasai, where the Sultan at those days, Maluku Saleh, ordered Panglima Laut to find a good fish for Marco Polo. And then Marco Polo said that Panglima Laut served him with a big fish, Pak Martin, in 13th century. So in fact, this group is long times ago, but this group during the independence quite no more active, because this other community until 2000, when I was elected as General Secretary of Panglima Laut, and then I tried to revitalize this group during the Aceh conflict. But fortunately, this group now well known everywhere, and I serve to them. Even though because we have unwritten law, we should help any people who are problem in our waters in Aceh. So that's why we not only, as you know, that Aceh border not only because we are very our border country with India, Sri Lanka, and then Maldives, Andaman Sea in Thailand and Malaysia. So if we have any problem in regional issues, regional issues should will be affected to our region. Like before, we have problem with Sri Lanka when Tamil issues, Tamil Island issues. We have 2 times to help this group when they are stranded in Aceh. First in Lok Nga, secondly in West Aceh. And then because of the conflict in Myanmar, and then the problem of Bangladesh government, Bangladesh there in Cox's Bazar, I think, and then many of smuggling issues also for human smuggler issues. So Aceh is not in fact the focal point for this refugee to come, but because of the problem of water, the problem of wine, and then sometimes arrive in our place. But we have the rules in Panglima Laut that we call that one hukum adat laut, or that mandate the Panglima Laut to maintain the security of the sea and social custom. So that the mandate, this according to our rules, this only traditional rule, unwritten law only. But during my terms as Panglima Laut, I have written this this law, and then just to, in fact, to not to written, but to what we call codification of the law of the adult outlaw. I do this in 2000 to make all the new generation, because it's quite different from the old generation. They are morely can memorize on their mind, but because a young one may be impossible because the elders pass away one by one. So I collecting the ideas from the elders, and then I try to I do the codification. So I think this book now many as the source and the resource for study of Panglima Laut. That's what I did in 2000. According to our local wisdom, customary law in Aceh, when we encounter a boat breaking or people drifting away on the sea, you see that, then the fishermen who see must provide assistance. This already mentioned that in our our custom. So that's why, but now that's why when we face that's many refugee from Sri Lanka before, and then for Rohingyas now, when the Panglima Laut see on the found them in the sea, what we call drifting there, and then automatically, because this what we call in our language alam bawah sadar. How to say that, Mbak Fitria? This alam bawah sadar. So on our on the community, the fishermen mind, we should help these people. Sometimes when they will face a problem like with the authority, like what we discussed today. Some of them already what we call convicted as to save this refugee. But there is another case when the case in Biren before. Panglima Laut contact me as advisor now. They contact me partly. So now we face that this what we call refugee on the sea. What should we do? I said to them, you discuss with the authorities, with the Navy, and then with the police, water police, how to save them. Firstly, because in our adat said we should save them. even though the government not allowed. But later on, because we have a good communication with the central government. Later on, we can communicate how to save them. Later on, take over by the Navy later on. But I said to Panglima Laut, even though according to our adat community, we should save them, but we should also follow the national law. If not, we don't want to have another problem like we have faced before. And then Aceh customary law of the sea, known as Panglima Laut, require all the fishermen in Aceh to have everyone whose life are threatened at the sea. Then we should, even though Marty John one day came to Aceh and then have the problem on the sea, you just contact the Panglima Laut. Surely you will help you because this not because of religion, because sometimes the people said that, oh, this because of the Aceh Islam and the Rohingya is Islam, so we have because of religion. No, because of the humanity, for the sake of humanity, because this inherited by the elders of the Panglima Laut since the kingdom of Aceh before. So that's why if you read the book Marco Polo, the travel of Marco Polo, he written about Aceh 12 pages and then mentioning about what the Panglima Laut did to him before in the year 1292 when he stayed in Aceh. And then because I don't mention a lot about the others because already elaborated by the other presenter, but I more concentrate of our adat Panglima Laut. So if if we have the law in Panglima Laut in the adat community, if it's known that a fisherman refuse to help, if they have a problem on the sea and the fisherman refuses to help, then he can be subject to customary sanction that we call hukum adat. The sanction range from administrative, sometimes, and then excluded from the membership, or to expulsion from the region. There's three sanctions we face that can face by the fishermen. So, but now all my brother and sister here. But now when because of there is the law that we sometimes because of politics, the problem of politics, sometimes of the government refuse to accept, but we use through diplomatic ways, through communication, firstly to save the people, the refugee. But if we face that there are what we call smuggler or human trafficking there, let the authority to investigate. It's not our authority. Yeah, it's not the Panglima Laut authority. The Panglima authority, they are very strict to their own tradition. They will help, and then we have our own territory on the sea. And then even though in the adat laut law, if we face that the community or the fisher or anybody who have the problem on the sea, we cannot go to the sea for 3 days until we settle the problem of this the community on the sea. So and then so I think because that's I think we can elaborate more on our discussion. So Panglima Laut in the capacity as a local wisdom that live and develop in Aceh, helping people who need help at the sea is part of the customary law in Aceh that live for generation in Aceh and is still practiced today. So we have 173 Panglima Laut in each fishing community in Aceh. So in surrounding Aceh, you can find them. They are not paid any salary, nothing, because they are respected men on the sea. So if we have problem on the sea in Aceh, automatically the fisher will help you. And if the fisher will not give support or give helping to the needed, and then the Panglima Laut can give put a sanction. There are two. First, Panglima Laut as the law enforcer, and then Adat Laut as the law itself. This one of, I think, the pluralism in law context. So even though Panglima Laut now under the law of governing of Aceh, Loga number 11/2006, this institution recognized by the state, recognized by state as the Adat institution, and then as the partner for the government in all sector, including with the social problem on the sea. I think this my my topic, but I really hope, in fact, the problem of Rohingya will be settled soon, so will not be affected to what we call political regional problem in Southeast Asia and South Asia. I think all of us should do how to persuade the Myanmar government to accept this refugee, these people back to their homes, and then I hope in the future we can, because we don't want to face this problem, and then we don't want to be my community, the Panglima Laut or fishermen community in future will be convicted to help the needy one on the sea. Thanks. This from me.
Thank you so much, Pak Dr. Adli. It's very important remarks, that you just mentioned about, this is the things that we don't want this case become the deterrence effect for the fishermen to help the Rohingyas in the future. And the things that I think what you have explained also like convince us that it's not only about the money. If they do need money in this fishermen, but the thing is that they have they are obeyed their customary law, the legal obligations, the things that the fishermen consider as a legal obligation, adat laut, customary law of the sea. So they must help the Rohingyas. This is the thing maybe that should be mentions and and should be all of us should not only in the court but also in the broader actors outside of their advocates, but also to make it more louder the voice. I think I will just give the opportunity for every speakers to answer the questions, and I find that many questions in the chat here. So I think I will read maybe, or anyone also invite. I invite also everyone to ask their question directly, but I think the first is I just means read the question from the chat. From Saifuddin Duri from IAIN Laksumawi Aceh, for everyone, for all of the speakers, how to get rid of criminality of solidarity in case of refugee in Aceh and the concern of the rescues. Oh, this is for Ance and for Professor Ance and for Mr. Jones. Also from Nikmah, Nikmah is directed to Pak Heru and Mr. Jones. Upaya hukum seperti apa lagi yang bisa kita usahakan untuk nelayan penolong pencari suaka Rohingya? And also I I think the things that can answer is Pak Heru, because Pak Heru very familiar with Indonesian system. Maybe you can answer the question. To Mr. Martin, I have a question to Martin regarding the theme being discussed now regarding the fishermen who saved the Rohingyas refugee, where this action is based on moral and a sense of humanity. Isn't this country also a threat to the Indonesian state, where there are foreign nationals entering the country, Indonesian territory illegally? Is the act of imprisoning the 3 fishermen where what are the constitutive element of this So what's your point of view to see the Indonesian government's policy concerning the progress of refugees transnational movement to nowadays, especially after the COVID pandemic? For Professor Ance from Rahmat Yulianto, being a non-member of 1951 Convention and Protocol of Refugees' Rights, is it possible for Indonesia to use word protection literally? Because in President Order number 125 years 2016, not specifying using word protection. Instead, it is just an handling procedures. So what your points of view to see the Indonesian government's policy concerning the progress of refugee transnational movement? This is a quite of random things. Maybe everybody is invited to answer the question, while I'm also like trying to see this one by one. Maybe from Pak Heru, and then Prof. Ance and Mr. Martin, please. Or if you have the opportunity to read before the question that directed to you, you are welcome also to answer this because I'm quite overwhelmed with this. Okay, Pak Heru, maybe you can start.
Okay, thank you, Dr. Fitria. I need to answer the first question from Nikma from Aceh, actually. What kind of legal efforts or legal remedy can provide for the fishermen in Aceh? I think, since it was already in Supreme Court, but we still have, I think, the peninjauan kembali, right? Like to review after the cassation or the appeal to Supreme Court has been took place, even though we haven't seen the SIPP or the document yet, but we know that it has been decided. Maybe we can find another novum, right? If we can find another novum or another new evidence, and we may do our best to filing what it is, peninjauan kembali, right? Or other means of legal efforts, like let's say the case examination or eksaminasi kasus. We can do like case examination, or another review, or filing amicus curiae, like friend of the court, something like that. So actually, we still have other things to do, this set of peninjauan kembali. So I think we can discuss about this later, Mbak Nikmah. And for a second question from, M. Pertiwi, I solicit Ibu or Bapak, perhaps Ibu. Indonesia is party to the UN Convention of the Sea, the UNCLOS, within which codified the principle of saving lives at the sea. Why this clause couldn't save the discussed Acehnese from criminal conviction? Was it because payments were made for the rescue? Would they avoid the criminal verdict if the payment from the distress did not happen? I believe so, Ibu Pertiwi, because they took the payment, even though the job hasn't been completed yet, because it's just attempt to do the rescue, because finally the Rohingya people rescued by another fisherman, and so the government boats or the police boat so it has not been completed yet. But they also, because they took the money, or at least they would like to take the money from Sahidin and from Adi Jawa, right? So the words or the terminology of people smuggling actually come up because it involving the money, involving the payment, not just rescuing people from the sea, as actually mentioned in the unclosed article. And also because they follow the order from Adi Jawa and Sahadin, so they like to go. They went to the sea by actually following the coordinate from the SMS as shown by Sahadin. So I do think that the judge or the police, the prosecutor, believe that this is not just rescuing people, but more look like people smuggling case. And then other question from Pak Bilal. Oh, Pak Bilal, are you still in Holland, Pak Bilal, or in Bandung? Yeah, actually, I don't have the cassation verdict yet from Mahkamah Agung, but I get the news. Even it already come up in the newspaper and the online news that it already been decided that the case was rejected by Supreme Court, by Mahkamah Agung. So I don't really know what the argument from Mahkamah Agung, but I believe this is almost the same argument with the High Court or the Judek Fakti in High Court in Banda Aceh. I think that's all from my side. Thank you so much, Bu Fitria.
Thank you, Pak Heru. Maybe I will ask Professor Ance to answer the question, some question directed to you.
Okay, well, thank you for the question. They're really interesting. I wanted to start by saying that the case of Faisal and the two fishermen is particularly interesting because what started as a smuggling operation ended in a rescue. So although we have all these legal norms, sometimes reality is a bit more complex because Faisal was initially approached to pick up 34 people from the Rohingya boat, not 99, only a small section, presumably those people who had paid to be taken to shore. And we need to remember that these boat journeys, they're often very long and people end up stranded for a variety of reasons. First of all, Malaysia has been very active in pushbacks. They send these boats out again to the sea, so that the time that people spend in the water gets longer. And the second reason why people end up stranded is often because those people who have organized the journeys are also trying to squeeze out more money from them. And they do this by contacting the relatives in Malaysia to make additional payments. So this is really important to bear in mind because this explains why only some people were supposed to be picked up by Faisal. Now, often we think to help somebody and prevent this person from drowning, this is rescue. The moment money comes in, well, that makes it a dirty and illegal deed. But I urge you to think again, because imagine you are a person stuck in Bangladesh and you need to go to Malaysia. If you're an ordinary person, you will not have a boat, you don't know where to go, you don't even know how to get a boat, you are in a way dependent on people who facilitate this journey. We call them smugglers, we call them facilitators. Some are really in for the money. Some want to take the last bit of money you have to take you from A to B. But the important point here is to make such a long journey, this can be done without any money. And the same thing in a way is also true for Faisal. He was hired to pick up 34 people out of the 99 from the sea. He did accept money because he does not own a boat. He would have to go to a cooperative and rent a boat, and that would cost him at least 10 million. So even though Faisal was paid money to conduct the act of smuggling, that's not a profit that he was making. This was also the money he had to pay to enable himself to go out. Now, so he gets the money, he rents the boats, he goes to the sea, and all of a sudden he realizes that the boat the Rohingya are on is sinking. The engine has failed, the pumps are not working. Now he's confronted with this fundamental decision. Is he only going to rescue 34 people as what he was charged to do or asked to do, or is he going to take on board 99 people, even those people who have not paid anything for their rescue? Now, because he is punya hati, we could say, he's aware of the adab laut, the hukum laut, he cannot allow these other people to drown. So he takes on board everybody, all of the 99 people, and he continues to the shore. And probably this would have worked out without causing much of attention, but he was very unlucky because now the engine of his boat breaks down and he will have to ask for additional help. And the moment he asks for other people to come and help, word gets out, the message starts spreading. He is basically prevented from coming on shore. And there's basically 2 days almost that get wasted because all these discussions are going on in Aceh. What shall we do with this boat of the Rohingya? Eventually, there is enough pressure from the public in Aceh to decide the authority must grant this disembarkation. So the Acehnese are basically or the Rohingya are basically coming to the shore, and as Mas Hero explained before, they're doing COVID tests, so on and so on. But I mean, what I really would like to point out, like some countries like Indonesia, they include making a profit as part of the definition of smuggling. And as soon as money comes in, it's quite easy to say, oh, you're not helping, you're just trying to make money. So therefore you can go to jail and stay there for 5 years or longer. Other countries in Europe, they actually have now gotten rid of this financial benefit paragraph, and they can still jail people for certain periods of time. Now, the thing is, what makes the legal provisions in Indonesia particularly difficult is that even the attempt to smuggle somebody is criminalized. And it's criminalized to the same extent as actually conducting a successful smuggling operation. So even somebody who has not yet crossed the border between Malaysia and Indonesia or between Indonesia and Australia can go to jail and spend 5 years there. And I mean, whenever there would be an attempt to revise this paragraph in the migration law, I think this would be something the lawmakers could be urged in Indonesia to rethink whether they really want to attempt, if they really want to punish people who attempt the act of smuggling with the same punishment. So that's one thing I wanted to say. Then there was a really interesting question by Mas Bilal, and he had been asking, well, is it possible that there were no smuggling networks in Aceh before? Or why were there no other cases to be found in the depository of the Mahkamah? Now, well, I dare say, of course, there will have always been networks in place. I mean, not just to bring in Rohingya, but I mean, Aceh, when Aceh was facing the conflict before 2005, a lot of Acehnese would try to flee to Malaysia to save their own lives. And again, you can't swim to Malaysia. You will need somebody who will take you by boat. And it's not a long distance, for example, between Indonesia and Malaysia. So any person with a boat can probably take you. So there will have always been some structures in place, but the police probably did not really pay a lot of attention to the same extent that Acehnese and of course also people from North Sumatra were involved, taking some of the Rohingya and taking them over to Malaysia. So for a long time, the law authorities, they have ignored what has been happening at sea. It was not a priority of their daily work. But we have to ask, why is it possible that, or what has caused them to now all of a sudden become interested? Is it a general fear that more Rohingya might be ending up in Indonesia, or is it something else? Okay, maybe I stop here and then connect later on.
Very interesting answers. And I go to Martin, please, Martin.
Thank you, Fitria. And no, a wonderful description of the complexity, I think, Anjay, that you've teased out there, and I agree completely with kind of your questioning of exactly kind of how we try to apply what are often kind of what we often think are very fixed categories to actually much more complicated categories. In terms of the questions, I was asked a question in terms of understanding the criminalization. And I suppose there's a few different ways of understanding what could be done. One has to do, as Anjay said, with amending the particular provision, Article 120, or the related provisions that criminalize attempts. Although I'm not actually sure whether, attempt generally in criminal law is prosecuted as the crime itself. I mean, similarly with conspiracy, and one looks at the worst possible case of a trafficking operation or even a smuggling operation that ends up killing people. And as a legislator, I would imagine you would still want to have some tool at your disposal to hold those responsible for perhaps recklessness, if nothing else, in the smuggling to account. But certainly amending the law to provide for an exception would be one possibility. There's often in domestic other areas of law, so-called Good Samaritan laws that protect from liability, criminal or otherwise civil liability, people who act to help other people. It occurs to me that in the Indonesian context, you have a similar provision. I'd be interested with Advocate Hero's thoughts about the analogous provision in Indonesian law strikes me as being in the law on the protection and management of the environment, where Article 66, if I remember correctly, says that those who struggle to enjoy the right to the environment or anyone struggling for that right should be protected from prosecution. So I wonder whether positively introducing a similar provision either into a revised presidential decree or into the Immigration Act itself would be one possibility. The other possibility, which is legally easier in terms of avoiding criminality, is exercising discretion, which in a sense has been done already, right? I mean, and Anjay's closed with her reflections on why was this particular case prosecuted. I mean, in a sense, we have to recognize that by and large, previous cases were not prosecuted. And that may be for all sorts of kind of largely irrelevant reasons having to do with resources also. But there was some, to the extent that there was a decision made, one could continue to make those kinds of decisions. Neighboring states, for example, in protecting refugees, Malaysia in particular, criminalize being a refugee, but they have, with varying degrees of successes, used prosecutorial discretion and guidance issued to prosecutors as a way of holding back those punishments. They won't amend the immigration laws, but they will hold back the exercise of those laws against particular fairly narrow group of refugees, so that they won't be punished. So the introduction of some sort of guidance to prosecutors around the circumstances and who would get prosecuted would be something else. And then the final thing to say in response to the question of whether I think that the Rohingya coming ashore is a threat to national security, I mean, I recognize that a defining feature in our current age of a state is its ability to police its community. I mean, its borders and who gets to come across those. But I mean, I think that Professor Adley's comments are really more specifically address this issue, right? I mean, from his point of view, the Indonesian legal order itself recognizes the rescues. And so it's actually a question then not of whether these people are breaking Indonesian law, but it's about reconciling different types of Indonesian law, the Acehnese law, the customary law, with the national legislation. And, so whether, I guess the first thing to say is I'm not sure they're actually breaking Indonesian law. And then the second thing to say is, I mean, I think by any account, and I appreciate, being an academic based in the UK, I always hesitate before complaining about other states' reluctance to take upon refugees, because the UK is notorious for refusing to take in refugees. But having said that, I think by any account, 99 Rohingya coming ashore in Aceh is not a threat to the national security of Indonesia, a country of 300 plus million individuals, and certainly coming ashore to a community that has historically not just rescued them, but I think it's fair to say welcomed them. And as Adli himself pointed out as part of the account, and NJ too, I think, the rescue was in fact completed in this particular case because of pressure from the local community. So in that sense, I find it hard to understand how rescuing a relatively small number of people would be a threat to the security when the community itself seeks to further those rescues. But yeah, I'll end it there. But fascinating questions. Thank you very much for them.
Thank you, Martin. And I think for Dr. Adli, there's it's not a question, but a statement from Nikmah, one of the lawyer from Aceh. She said that we would have asked you if we knew it, that for giving more advice to us. Okay, maybe next time for the judicial review, Dr. Adli, do you have any comments about that?
I think for we should state it that that in fact for the future to help, mostly because of humanitarian cause, not because of they get money or somebody paid for them. But very interesting, I think there is one question here. Is it that in 2015 mostly the fisher help because of humanitarian cause, but in 2020 some of them receive money? So I think this a change of value, because in our adult law we not recognize that to have people because of we get compensation from that. Jadi, sorry, I translate in bahasa because some of also ask to translate bahasa. Kita dalam sistem hukum adat laut itu menolong itu adalah merupakan aturan yang diwariskan dari moyang kami, bukan karena adanya pembayaran. Jadi kita tidak mengenal itu dengan membayar. Jadi siapapun orang yang musibah di laut itu, according to the adat laut, we should help and help them. Itu sistem adat laut yang kita miliki di Aceh. So that's why we still exist up to now, even though there more than from during the Marco Polo in the 13th century up to 20th century now, the adat laut still exists, will exist in Aceh especially. So hope I think we please help us. And then please help the Panglima Laut, will help the Acehnese community and the fishing Aceh community. Don't criminalize these people. So if you have problem in future, Nikmah, maybe you can contact me. I am ready to be a witness, like to be an expert witness on the court. So like I do that some of expert witness before in the West Aceh, also in the case of the Panglima Laut criminalized by the prosecutor there. Because my study more concentrate on the Adat Laut, and then now I am formally, but now I study more concentrate on, I am now as the expert for the Minister of Land in the Adat community also. Thanks. Hopefully we keep contact, and then I think how the board we work for humanitarian cause, we work for humanitarian action. This humanitarian action will be survive and sustain forever. Then it is part of our teaching in the Adat community in Aceh. Thanks.
Very, very nice final remarks. Maybe I will give some minutes for Pak Heru, Mr. Martin, and Professor Ance to give like final remarks before we closing the the seminar. From Pak Heru, maybe.
Yeah, thank you, Ibu Dr. Fitria. Yeah, perhaps we need to, let's say, we need to discuss more with the policymakers, with the stakeholders in this case, not just the legal apparatus, not just to the court or to the judges, to the prosecutor, the police, but also to the lawmakers about how to deal with this problem, because it perhaps will be happen again in the near future, because the influx of refugees are still perhaps will still coming in the near future. I guess, because the problem in Bangladesh, problem in Myanmar is still to take place until now. So I believe that we will have not the same problem for the so perhaps the policymakers, we can discuss with policymakers to extend this this thought, this perception, opinion. So Indonesia perhaps, or perhaps we can suggest for the amendment of the immigration law, or let's say another suggestion to create special law on refugees, or other mechanism, or even to amend the law, the purpose of the Presidential Decree number 125 2016, so it can be more complete, and we can operate them to handle the case of refugees and the people who help or who rescue refugees instead of the state apparatus. Thank you, Bu Dr. Fitria and everyone.
Thank you, Pak Dr. Heru. Before to Martin, I think I will, let the participants to also fill the forms for the attendance, also for the certificate. Please do so. And okay, to Martin Gens, your final remarks, please.
Oh, sure. Thanks, Fitria. I mean, thanks again for bringing us together. No, I would second Heru's comment that the solution is probably more than just a legal one. I mean, certainly more than a solution to be found by lawyers. And at the very least, we need to broaden the legal community to bring in experts like Professor Adli, to bring the conversation so that it's not just about national immigration law, but it's also about refugee protection, but it's also about customary law. For me, one of the ways forward is to recognize that we won't necessarily find solutions elsewhere, that this is a problem that other countries are dealing with. I don't think there are solutions. I think there are problems in many other countries, and we've listed many of them, for example, in Europe. And I think that provides an opportunity both for the Acehnese as well as the larger Indonesian community to lead the way forward. I mean, I think there's really something interesting that is going on in Aceh. I think there is really something interesting that can be further developed within Indonesia more broadly. And I think for me, it really speaks to this question about what is the role and how can we best recognize local communities in protection. I think there are limits to what the state can do, and certainly we have seen there's limits to what the state will do. And really, for me, the way forward in terms of refugee protection is trying to figure out a way in which we can create a framework that facilitates local communities, particularly where they're willing, as is the case in Aceh, to take a greater lead in setting the standards as well as offering protection itself. Thank you.
Thank you, Martin.
Fully agree.
So the last remarks from Professor Ance, please.
Well, first of all, thank you very much for organizing this seminar. It was very interesting also hearing your questions. And I agree very much with what Martin and Mas Heru have said. Generally, I would like to stress that I always welcome academic interest that seems to be growing in Indonesia among young people who have suddenly taken interest in refugee affairs. That's a positive development over the last 10 years. And both academic and public interest can, of course, help to shape the discussion and to provide input to lawmakers and decision makers. And one question that we got to be asking these lawmakers is, will the imprisonment of fishermen really end the problem of people smuggling? Will there be no more exploitation of the Rohingya who are trying to find safety? And my answer probably is putting fishermen into prison is not going to solve this problem that's happening out there at sea. This punitive approach, we have seen it, for example, in West Timor, when a lot of local fishermen got to jail there for bringing asylum seekers to Australia. What resulted from this move is that suddenly it was a lot of people from Java who would then come and transport asylum seekers. So it's basically just pushing the problem from one place to another. And as you know, fishermen are usually the poorest of the poor in Indonesia because they overfishing and environmental problems. They're always going to be easy prey for anybody who wants to hire them. So even if the imprisonment of Faisal and his friends will send out a negative message maybe to other Acehnese fishermen, people in Java, people in other parts of Sumatra will not know and would still be vulnerable for being exploited or abused as smugglers, because they are the most visible segment in the people smuggling chain. And even though I think that the milk has spilled for the case of Faisal, the Mahkamah Agung has made its ruling. From what I understand, there is another investigation taking place right now in Aceh concerning the rescue of Rohingya that happened in December. And of course, I would also be very much interested to hear from our friends in Aceh at some point what is actually happening with this new investigation, whether it's going ahead, whether there will be a trial, and whether maybe there will be lawyers that receive briefing and preparation to make sure that this new group of people will be treated differently. That's from me. But once again, thank you so much.
Thank you very much, Professor Ance. I cannot, conclude because many important things here. And then one thing that we should do is we cannot stop here. We have to make it more larger, and there are academicians here. We have also like NGOs activists. We have students. We have many people who join this, and we have to make sure that we keep going on helping the Rohingyas. Thank you again for all the speakers, and it's very lovely evenings to have to have you all here. And I will I think I will hand my then I think I will give Dr. Mashrofah to close the seminar. Give the Dr. Mashrofah, are you still there?
Yes, of course.
Okay, thank you.
Until the end.
Oh, thank you. Yeah.
Okay. Okay, thank you, Dr. Fitria. And ladies and gentlemen, all participants, please give a big applause to all speakers tonight. Thank you so much for Professor Ance Misbah and also Dr. Martin Jones. And thank you so much for Dr. Adli Abdullah and Dr. Heru Susetio. And before we close or we end this international seminar, there will be a certificate for all speakers, and I would like to call upon the Vice Dean for Academic Affairs, Dr. Shahrul Adam, MAG, who will give the certificate of speakers. The time is yours, Dr. Shahrul.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Okay, we are very thankful for all speakers on behalf of the Faculty of Sharia and Law in Jakarta. I would give certificate to all speakers. First, for Pak Heru Susetio, and second, this is the certificate, Pak Heru.
Yes.
Okay.
Terima kasih, Pak. Terima kasih.
Okay, thanks, Heru. And the second certificate for Professor Ance. Where is the Professor Ance Misbah? Thanks for Ms. Ance Misbah. The third for Mr. Mr. Dr. Martin Jones.
Thank you very much.
Okay, thank you. Thank you very much again. And the last for Dr. Adli Abdullah.
Oke, terima kasih banyak.
Pak Adli Abdullah. Thank you very much again for all speaker. Very pleased for having all of the all speaker and participant here. And thank you. See you all in the next discussion. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Dr. Syarul Adam, as a Vice Dean for Academic Affairs. Ladies and gentlemen, this is the end of the International Seminar on Refugee Law. Once again, I would like to say thank you so much for all speakers and participants till in the beginning of seminar until the end. And even we are still together right now. Okay, thank you so much. See you next time. Wabillahi taufiq hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Yes.